All right. Hello, everyone, and welcome to Age Wisely Atlanta with Sonia Peterson, where we bring you the latest and most valuable information for seniors and their families. Today, I am thrilled to have a special guest with us, and that is attorney Patricia Ammari from the Ammari firm. Attorney Ammari is an elder expert law attorney with extensive experience in estate planning, Medicaid planning, probate estates, guardianship, and conservatorship. She is dedicated to helping seniors and their families navigate legal complexities with compassion and expertise. In today's interview, Attorney Ammari will share her insights on getting your ducks in a row with wills, trusts, and healthcare directives. So join me in welcoming Attorney Ammari, and I appreciate you being so much here today, and we'll get started by letting you tell us a little bit about yourself, your experience, and what drew you to the elder care law field.
Thank you so much for having me today. I really appreciate it. I always love to have the opportunity to tell folks a little bit more about what I do, because I love to avoid what I call the if onlys. If only I had known X, then I would have done Y differently. And so we can help fix those messes, but we love to avoid them in the first place. So thank you so much for having me today.
Thank you for being open to come. I really appreciate it. And I'm looking forward to learning about the if onlys.
Mm-hmm. Absolutely. So, as an elder and special needs law attorney, we help families. One of the areas that we do help with is estate planning, estates and trusts and wills and those kinds of things. So, a question that we get a lot is, what is a will? And, do people have misconceptions about wills? And sometimes they do. So a will is a document that allows you to say who gets what when you die, who's in charge, and then certain rules of the road. For example, I don't want my grandchild to receive their inheritance at 14. I want it to be held in trust for them until they're 25, until they're a little bit more mature and can handle that. And that's just an example of the sorts of rules of the road that you can put in. But it only applies after you die. So sometimes people think, okay, well, my executor, that's a thing right now and they can do things for me. And actually, an executor doesn't really come into play until after you die, and the court actually blesses them as the executor. So that's an important thing that sometimes people don't know. Another thing is that often people think that a will avoid the probate process. And while the will is wonderful at you getting to say who gets what and who's in charge and those kinds of things, it does not avoid the probate process. It does. That's how the will is effectuated, through the probate process.
I think that comment about people thinking that wills will help you avoid the probate process is $1 million gem, because I know personally myself, I've heard so many times, have a will, get a will, and that way you don't have to go through probate, blah, blah. And then, in learning that was not the case, it's like, wow, so what's the reason to have a will? But like you said, it does allow you to decide or appoint who will be over your estate. But that still has to go through the court process, and the court still has to bless, I guess we'll say bless the person, or give their blessing or permission on the person that you have placed. So,
right.
So tell me, in order to avoid probate, you have to have what? A trust?
So a trust is one way that you can avoid probate. And a trust is, kind of a made up thing in the law, a little bit like a corporation is a made up thing in the law. But the made up thing with a corporation is it's a made up person. So it's considered a person for all purposes. With a trust, it's more of an agreement. And it's an agreement between the person that creates the trust. A trusted person calls the trustee, who is going to effectuate the wishes of the person who creates the trust for the benefit of someone. And, the way I like to describe it is it's like a box, and it's like a box with instructions. So if you put your asset inside of the box, then the trustee will have the instruction manual and, most importantly, the power to address those assets. And so that can be a very important thing to allow you to control your assets now during your lifetime, as well as what happens after the fact. So being an elder law attorney, we do focus sometimes on what happens in the case of disability, because the older people get, the more likely they can become disabled cognitively. And some of the numbers that I've seen out there from the Alzheimer's Association and whatnot is by the time you're 85, about 50% have cognitive decline.
No.
And so that's a pretty big number. And so that means that if you live long enough, there's a really good chance that you're not going to be able to keep making decisions for yourself. With a trust, you can actually decide under what circumstances you'll be determined incapacitated. So in other words, you can name some folks that you agree that are trustworthy and that you would feel comfortable making that decision. And then you get to say who's in charge during that time period and what they're allowed to do with your money during that time period. And it's a beautiful process on the front end as we age. And then when you pass, it's sometimes referred to as a will substitute, because it does do what a will does in the sense that it puts someone in charge. It says who gets what, and it also puts certain rules of the road in place, but without the probate court. And while Georgia used to be considered a relatively probate-friendly state, I don't think we can say that anymore in a lot of cases. And we've seen just massive, massive delays in many of the metro courts. And those are the ones that we practice in. I like to say we have like 20 different, counties in the metro area, and that means a different probate court in each county. And along with that, a different set of rules. So it can vary based on where you are, but what we've seen is extreme delays, and our clients get really frustrated at having courts involved in what they think is just, and understandably so, is just the passing of property from one family member to the other family member. And so why do we have to follow all these rules? Why do we have to do all these things that maybe don't even apply in our particular instance? And that's because the probate rules are written with a broad brush, so they cover everybody. And so they don't take anybody's individual situation into play.
Okay. Now, when we talk about trust, there are different types of trust. So can you, tell us what's the most common type of trust that you see?
I would say the most common type of trust is the trust that we've been talking about. One that will help manage your property for you as you age, and then will allow you to decide, who gets what and avoid that probate process. That trust is a revocable trust, which means you can change it at any time. You can revoke it and get rid of it altogether. You can put things into it. You can take things out of it, and you maintain total control. Because you maintain total control, for IRS purposes, it's yours. And for creditor purposes, it's yours. So there's no creditor protection. There's no tax implications with respect to that. It's just considered yours. So that's a good thing in some ways. So there's not a special tax return and, those things that have to be filed. But, it doesn't provide those additional sorts of benefits. Another trust that we sometimes do is something, it's an irrevocable trust. An irrevocable trust is a trust that you cannot revoke, you cannot change after the fact. And it may have tax benefits or tax consequences or not, depending on the terms that are put inside of the trust. So one type of irrevocable trust that we use is for Medicaid planning. And so in that trust, you are not the you may create the trust and are the grantor, sometimes referred to as the settlor, but you are not the beneficiary of that trust. And so either for income or assets, so that then those assets after a 5-year look back are no longer counted against you. And so that's one irrevocable trust that we do. Another kind is sometimes when we're helping folks with special needs who have been determined to be disabled by Social Security, they can sometimes receive benefits, both health benefits and also a monthly stipend. And in order to keep that benefit, sometimes it's necessary to do an irrevocable trust that follows the federal government's laws for trusts that are basically referred to as special needs trusts. So it allows them to still get the benefits that they're otherwise entitled to. These assets in the trust don't count, but then after they pass, Medicaid may be paid back from those assets. And so it's a great way to keep getting needed health care. But there's, something on the back end. So there are so many different types of trusts out there. Other states recognize asset protection trusts. Georgia, we really love our creditors. I don't know why. But, we don't have those in the way that some states do. But, those are other reasons to do a trust.
But in having a trust, you basically place someone in a position of, I guess we'll say, authority, or someone that still is a decision maker regarding that trust. Is that correct?
Right. And in the case of the revocable trust, you're your own trustee for as long as you can be. So you stay in total control. So it just depends on the type of trust, what your goals are for that trust. And then we, draft based on what your goals are, taking into account all kinds of different things, including taxes and trust law and, sometimes public benefits laws and whatnot.
So in the case of an irrevocable trust, what are some things you would recommend someone think very seriously about in considering who they place as that trustee?
Okay. So whenever you name a trustee, or a financial power of attorney, or anyone that's going to have authority over your funds, it's really important to choose someone that you implicitly trust. And I often tell my clients, because they can wipe you out tomorrow. And so it's really important that you not put anybody in place that you're not 100% sure that will honor your wishes. Because it is considered, a fiduciary level of care that they owe to you. A very, very high level of responsibility is given to them. So there is a very high level of responsibility there, but it's very important that you do trust the person. And if there's not a trusted person, there are professional trustees that can sometimes serve, and that makes sense in certain circumstances. And sometimes we'll help our clients find a professional trustee that can do that. And, sometimes there's benefits to using professional trustee, right, because there's an independent person that's not involved in your family. So you don't have one, child that's, acting, in a position that might cause, family strife. So there are a lot of reasons why, you might use a professional trustee.
Right. Yeah, that definitely makes sense. So, what about a healthcare directive? That's something else that I've heard about. So can you explain how does that work?
Absolutely. So it used to be that we had healthcare powers of attorney and living wills. And the healthcare power of attorney portion of it was the part that allowed you to name a healthcare agent. Who do you want to make decisions for you regarding your health and safety and those kinds of things when you're unable to do that yourself? And then the other piece of it is that living will piece of it. The living will is when you decide what sort of care you want at end of life. And so now the updated term, the modern term for those documents is an advance directive, and it's basically been consolidated to include those two things. So the first part of the document is choosing that healthcare agent. The second part of the document is where you get to choose what you want those decisions to be in end of life. And we're pretty conservative in Georgia, so the two circumstances in which you can choose end of life decisions are as if you are in a permanent vegetable state, or if you have a terminal condition and are about to die in a relatively short time. And the example that I like to give is those last few days of cancer when you're not able to communicate anymore. Mm-hmm. And so, you can choose between do everything you can for me under those circumstances to let me go naturally, but give me pain medication and, some things in between. So those are decisions that you make in that second part of the document. And in the third part of the document, it gives you the ability to tell the court who you would want to be your guardian if ever you needed one. Now, when you do an advance directive, you're hoping that you're not going to need a guardian because you are putting someone in place to make decisions. But there is one set of circumstances that I can come off the top of my head with. And that's when someone develops dementia and they begin wandering into the street. They begin, using the gas stove and, nearly burning the house
Mhm.
down, those kinds of things. Under those circumstances, if a loved one needs to be put in locked memory care, that's something that your advance directive does not provide authority for. So for that, it does require them to go to court to get the authority to do that. And so that's a
Mhm.
limited circumstance when you still might need a guardian. So you get to tell the court, who do you want to be the guardian if ever you would need one? And you can choose your healthcare agent if you want, or you can name some other person that you might prefer to stand in that role if ever that became necessary.
Okay. Okay. Well, so like we talked about the name of this being, getting your ducks in a row. So we've talked about wills, we've talked about trust, the healthcare directive. Are there any other documents that you feel are necessary outside of these when someone is looking to make sure that they have everything kind of buttoned up?
Right, right. Well, definitely those documents are important. And I would like to talk a little bit about what happens when you don't have the documents, if that's okay.
Oh, yes, please.
Yeah. So, in addition to, well, these are the benefits of having the documents, sometimes it's really important to know, well, what happens if I don't have the documents? And sometimes that happens because people just don't get around to it. And so, but let's talk about what happens in that circumstance. And sometimes people are really surprised as to what happens in that circumstance. So when someone does not have a will or a trust that covers their assets, then the state of Georgia has a plan for you. And that might be a good thing or it might be a bad thing, depending on whether or not what your views are and the state's views are, whether they equal out or not. So if you're married, most of the time, married couples will leave everything to their spouse. And that's not what the state of Georgia does. So if you're married, your spouse you will share with your children. So if there are 3 children, for example, the spouse will get at least a third, and then the children will share in the other 2/3. And particularly if it's a first marriage, that's not, what most folks want. They don't want, their children to inherit until the second of them to die. And if it's a situation where the couple has young children and there's not a will in place, then not only will the children get 2/3 of it, but it will go into a conservatorship for the children that the court will be in charge of. And the parent who survives will have to go to the court and ask before they can spend any money. And there's been this overriding view in Georgia that a parent has the legal responsibility to take care of the child. So
Right.
courts have often not allowed the surviving parent to use those funds to support the child. Now, the law is beginning to change with that a little bit, but that is a huge shock for parents of younger children because that is most definitely not what most folks have in mind. And the reason, again, we talked about the probate rules and all those rules, broad strokes for everybody. It might make more sense if it's in a third marriage and you've got children from multiple children and whatnot, and you want to have something for the spouse, but also something for children from other marriages. So again, those rules have to apply for everybody, and that's why they exist. With a financial power of attorney, if there's no financial power of attorney in place, then the family has to actually go to court to be named the conservator for their loved one. And that involves, a hearing that they call it a hearing, but really it's a trial. And it's a whole legal procedure that takes months to go through in order for you just to be able to make decisions for your family member. And, it can be expensive, it's time consuming. And then your family has to go in and tell all the embarrassing things to the court so that they can legally find that you're incapacitated, take your powers away, your authority away, and your legal rights away, and then give them to someone else. And you know what? The person that shows up to court might not be the one asking for that power, might not be the one that you would have wanted in charge.
Exactly.
So there are some really big consequences to not having those things in place, which I think is really important for people to know. Also, and sometimes, your family does need to sell that house so that they can go ahead and take care of you, and they may not have the ability to do that. And then also sometimes we see is that people are waiting to do probates, like after the first spouse dies.
Yes.
Sometimes the house passes automatically and sometimes it doesn't. And either way, the surviving spouse doesn't do anything. And if it didn't pass automatically, it can have some really negative tax consequences for the family as well. So it can be, kind of scary sometimes to go see a lawyer, but we really try and make it, as just painless as we can. We're nice folks, we promise. Just because we work in a law office doesn't mean, that we're scary. So come see us and let us help you, or another attorney who can help you take care of those things.
Yeah, I mean, just that last 5 minutes is enough to make you want to get things in order, because you are absolutely correct. So many people think that everything automatically is going to go to the surviving spouse, and that is not the case.
Mm-hmm.
And it can get really heated and really dicey when people have these assumptions that this is going to belong to them. And as you mentioned, first marriages, second marriages, adult children in this marriage, but minor children in this marriage, it can become very convoluted. So we are very, very thankful to know who has all the answers. And like I said, this has been really, really, really informative. So one thing I would like for you to share is how you can be reached. And I'll also put your contact information in the description of the video. But if you'd like to share how you can be reached and where your offices are located, that would be great.
Absolutely. We're located in Marietta, Georgia. My telephone number is 678-609-3230. Again, that's 678-609-3230. The name of my firm is the Ammari Firm. And we can also be found online at www.elderlawatlanta.com.
Okay.
Yeah.
Thank you.
Thank you so much for the opportunity, to be able to talk to you about it and talk to your viewers. We really appreciate it.
You are welcome. I appreciate it. Like I said, I really appreciate you being open to come. This is information that people really need. And as you stated, sometimes I think people feel intimidated in, the thought of having to go to an attorney's office. So I think when people get to see you, it takes away some of that fear that they may have, and it lets them know that it's okay. She's open to sharing information. So
absolutely,
I'm definitely glad.
Yeah, for many people, it's the first time they've ever had to see an attorney. So
yes, exactly.